My name is Daniel Roth. I teach at the Pardes Institute for Jewish Studies in Jerusalem, and I direct our Center for Judaism and Conflict Resolution, which I'll say a little bit more about at the end of our session. I also am an adjunct professor at Bar-Ilan in conflict management and negotiation, which is where I did my doctorate. And I'm honored to be joined here with my co-facilitator for the day.
Dan Ben-Zvi, and I've been a mediator and arbitrator with ADR Services, which is a panel of mediators and arbitrators here in Los Angeles and throughout California. Since 2000, I've been arbitrating and mediating since 95. 81 to 95, I was a trial lawyer. Very happy to be here.
You all have in front of you your packet. In the packet, you'll find the source sheet that we're going to be focusing around the conversation. Also a printout of the PowerPoint, okay, that we're going to be using in guiding our conversation. And so we're going to start with having some lunch and studying in chavruta with the person sitting next to you. And we're going to, if you take out your source sheet, okay, which is this document over here. So we're just going to look at the first, this first source, which is found in the Talmud, but it dates to about the 3rd century to the Common Era, and it's really the foundation of alternative or appropriate dispute resolution in rabbinic literature, and it's going to be the starting point for our conversation, which is really about mediation, as the session is known, in Jewish and contemporary law and practice. And as you study this text, okay, with your study partner, first, you know, like any text, just any question that comes to mind, feel free to write it down. We'll try to address some of them, but we're going to really focus around 2 questions that will hopefully come up for you as you look at this text, which is, how can the first rabbi mentioned in this text, Rabbi Eliezer, how can he on the one hand say it's prohibited, it's forbidden to do what he's going to call pshara, or arbitrating for compromise, and at the same time praise Aaron, the older brother of Moses, as a pursuer of peace? Is that a contradiction? And think about how would you resolve that apparent tension within the text, okay? And that will open up the first part of our conversation, which is what are the different models of ADR as found in rabbinic law, in Jewish tradition, and we're going to compare that with what are some of the contemporary models of ADR today. And then the second part is what is behind the disagreement between the 2 rabbis in the text that you're going to find. One is going to say it's prohibited to do pshara, okay? It's actually a sin to engage in compromise. And the other one is going to say it's a mitzvah. It's actually an incredibly positive act. What's behind that disagreement? And again, there we're going to connect it into how can we weigh the advantages and disadvantages today of when to go to different approaches of ADR. And we're going to ask Dan to share what are some of the different models that are out there, and when, as counselors to our clients, would we want to refer to one model or another? What are the pros and cons of all of them? And lastly, we're going to take a few minutes to enjoy our lunch. Okay, so we're going to study this first text. We're going to give it about 10 minutes or so, and then we're going to reconvene and continue our conversation from there. Yeah, I would suggest doing it in 2s, and I'll share that chavruta, the studying with a partner, is not only a traditional Jewish way of studying, and it's core to what Pardes is all about, which is, you know, it's an adult education, open Beit Midrash place of study where we often are going to study in chavruta, but it's also a great model for conflict resolution training, because we practice kind of analyzing and hearing different perspectives. So as you go through and you have your thoughts, ask your study partner, how are they understanding these questions, perhaps in a different way. Okay? Great. How you guys doing? Any questions?
We have 3 so far.
Great. Okay, good.
Torah law or rabbinic law, as opposed to more civil laws, like.
Meaning, what's the case?
Well, not necessarily what's the case, but you can envision a world where it would be blasphemous to God to say that God's decrees are X, but let's go with Y.
But we're clearly talking about we're definitely talking about civil cases here. We're definitely talking about like some type of interaction between two individuals. Like we're not talking about like the laws of the Sabbath or anything, that's just, like we're talking about.
And why is that for the first entry? Is it a preceding clause? Like, where are you getting that this is an interpersonal dispute here?
Because the whole conversation is talking about bitzua and shara, which is by definition talking about within a court or within a civil case.
Okay.
That there's two litigants, and what is, how are we going to proceed in that case is what's going to be argued. Like the whole context in the Gemara there, and definitely, as you say, they're talking about a judge. Yeah, but what exactly what does it mean arbitrate for compromise, which is like a way of fudging that we don't know exactly what case they're talking about, is what we're going to have to explore. Like when is the debate taking place and in which case? So, okay. Okay, hopefully everyone's had a chance to at least do an initial read through this not so simple ancient text. And hopefully everyone has had a moment of what's happening in this text, and do I understand exactly? So, as a general rule of thumb, understand that we are studying a text that's over 1,500 years old, and therefore there is going to be, like in any legal text, but especially ancient texts, there's going to be a lot of ambiguity, a lot of questions that are going to then stimulate 1,500 years of commentary of people like ourselves reading this text and trying to grapple with what are some of the different questions that come from it and try to smooth it out and figure out what to go with it. It's through those questions and through those ambiguities that we're actually going to come up with some creative models for alternative dispute resolution and for some of the pros and cons behind those different models. So before we get to that, what were some of the questions, some of the bumps that you experienced as you were going through this text that might have been unclear? Unless everything was totally clear.
Perfectly clear. But then I'm a mediator.
Okay.
I don't think they're in conflict with each other.
Mm-hmm.
The way that I read the first, in mediator school, we learned there's I think it was Riskin's grid, but I can't remember. There's a grid, a continuum between facilitative and evaluative mediation. Okay, so evaluative is what the retired judges do. They get the parties in and they say, here's how I think this is going to come out in court, and you ought to agree with me. And they kind of twist arms and put pressure on the parties to compromise, versus more facilitative mediators who try to really work with the parties to achieve their own resolution that they feel is more, they take more ownership of, if you will. Right? So what I read the first rabbi saying is, I don't like evaluative mediation because that's not the party's decision, that's your decision that you're forcing on the parties. You're arbitrating a compromise, which is sort of the contradiction in terms.
Mm-hmm.
And I like the idea that the parties really are coming to their own compromise. Don't force them to do something, because then it's not really a mediated resolution.
So where do we, yeah.
Forgive me, jumping to the second one, I think he's really also supporting mediation, but in a different way. He's saying, if you go into a court of law and you prosecute something to a judgment, you can get a resolution, but you don't necessarily get peace. So it's a mitzvah if you can get the parties to compromise and come to their own resolution, because then you can achieve peace. And that's not necessarily a judgment, but it is a resolution, and that leads to more peace because they've done it themselves, maybe with your help, but you've gotten a compromise, and so he's supporting, in effect, alternative dispute resolution versus the court system.
Okay, so, and your name? Glenn, right. So, but just to clarify, I think the distinction, as I understand it correctly, it's a question of, who is imposing the compromise, and to what extent is there ownership on that process that's being facilitated maybe by a third party, but nevertheless the sides are really taking ownership on the process. We're going to see that distinction. I just want to clarify, though, is that, and this might not have been as clear in the English translation, that both Rabbi Eliezer, the first opinion, and the second opinion, Rabbi Yeshua, are talking about the exact same case. They're talking about the same process. They're both talking about the Hebrew word bitzua or pshara. Pshara is often associated with compromise. Bitzua, you only find it really in this text. It literally means slicing something down the middle. The word bitzua, we use it when we talk about saying the motzi on the bread. You do bitzua. You cut it in half. Yes. Yeah, so they're both talking about the exact same case. And then the question is, yeah. So one question is, all right, I mean, you raised a couple of great points, which is, what is the case that they're talking about? What is this arbitrated compromise? And what might be something behind the debate? Other issues or questions that came up when you took a look at this text?
So we had a couple of questions. One was, what's really the value behind each of these positions? Because they each refer to specific texts. And it looks like there's a different focus. In one case, there seems to be a focus on let the law cut through the mountain. So the law seems to be this definite thing, if you will. It's like a Platonic truth. There's an objective standard, and therefore that seems to be the problem behind compromise, because the compromise isn't reflective of this objective truth. So I guess the question is that really the value behind Rabbi Eliezer's position as compared to Rabbi Yeshua, who seems more focused, and this is in line with what Glenn was saying, who seems more focused on the human component, letting people process this, getting to the truth. Are they really focusing on different aspects, even though the conversation is about this idea of shara or boteh? That was one question. The other question that we have is this little kind of dangling participle about Aaron. Is that a third opinion that we just don't know about? Is it a counterpoint in anticipation? What's going on?
What's it doing in there? Exactly. Right. Excellent. Any other questions or comments? Because that's where we're gonna start with that question. Because I think that's going to be key to understanding. Wait, what are we talking about when we use the language bitzua or pshara or arbitration for compromise? What is this? We can't even translate it because it's unclear what is the exact process that we're referring to that they're having a debate over. Okay, but let's see if there's any other questions, comments. Yeah.
So I'm as amateur as you can get on this. So there's
No,
but it seems with Yeshua, he's being extremely radical in his opposition to Eliezer, because it's not just we have to move beyond judgment to get to peace. It's the moment you throw judgment in there, even as a starting point, you get rid of peace. Well, if you're doing that, it's kind of hard to find a middle ground, because unless you have the points in opposition, where's the middle? And it seems kind of pretty radical approach. Also, if jumping into the first one, if Aaron is if Eliezer is building in a sort of compromise position to his own position, the very last line in there is that what Aaron did was okay because he turned many people away from iniquity. I mean, Eliezer's first point is don't fear any man. So why do you care for turning them away from iniquity? Because you just do what's right anyways.
Great. Yeah, so Rabbi Yeshua, who's bringing up both justice and peace, saying the only way you can balance those two values and incorporate them both at the same time, in his opinion, is through doing what's called pshara. But we don't know what that is. So, pshara. Pshara is also the contemporary Hebrew word that we're going to use for compromise. Okay? And
sorry, just to read that though, the compromise, you have to have two positions that compromise. But he's in a way kind of rejecting the positions.
the problem with even using the word compromise, because we don't know yet what that process is. Is it the two sides agreeing to compromise by themselves? No, there's a third party there. So what is the role of the third party? So, okay. So
Am I jumping ahead by explaining my understanding of Shara? Do you mind jumping ahead?
Well, I thought what would be good is that we start with looking at what are the different models and what is pshara in this context. I mean, so what we want to try to explore is from this text, and we're going to see this as kind of a starting off point, what are some of the different models in Jewish, and then compare it to what are some of the models that are going on today in contemporary. How do those relate to each other? And that the entry point in the text to what are the models of ADR can be through this seeming contradiction of how can Rabbi Eliezer on the one hand say it's prohibited to engage in compromise, or whatever we're going to call pshara. At the same time, he seems to be the same person praising Aaron. So is what Aaron is doing by bringing peace between people, is that the same thing that Rabbi Eliezer just said you're not supposed to do? Is he undermining his own position? Is it another opinion that's saying that? Right? How can he seemingly say those two things? There were some commentaries in medieval times and contemporary that were so troubled by that they said there's no way, it must be somehow somebody else's opinion got inserted and it only looks like it's Rabbi Eliezer's opinion. Because Rabbi Eliezer seems to be against any form of ADR, meaning there's only din, there's only strict rule. Anything that's alternative is forbidden, prohibited, because it's compromising on God's law. But there were a lot of other opinions that said no, that there is something else going on. So everyone, if we look at what are the different, and we discussed, should we call ADR alternative or appropriate dispute resolution?
Which term was coined by former Attorney General Janet Reno. She said that the alternative should be court. Appropriate should be mediation and arbitration. If that doesn't work, then it's court.
So if we look at our text, we clearly have one option, even if it's not explained so much, of din, which is the regular classic possibility of going to court, a judge ruling according to the strict letter of the law. Okay? Our conversation seems to be something about pshara, that they're disagreeing about. Okay? Now, generally that's understood, as we'll see, is it's a judge, because we're talking about a judge in court who is ruling according to some kind of compromise. Oh. Now, the question is, what is the relationship between pshara and between Aaron being a pursuer of peace? That's where we're going to be able to define more clearly what this is and what that is. So we're not going to have a chance to read through all these sources inside, but I'll refer you in your source sheets to page to section 2, where it says mediation and ADR. Actually, we'll switch over where it says, it's source number 3, it says Rabbeinu Yishaya ben Eliad Ditrani. Okay? He's Italian, 13th century, deeply troubled by this seeming contradiction. And Ditrani, maybe we'll just take a look at the last few lines of this source, where it says, and there is no mitzvah. Okay? It's like 4 lines down from the bottom of that first source. He says, there is no mitzvah greater than this, and this is what Aaron used to do. Indeed, it is not allowed to force them, to coerce them, rather, to appease them and reconcile them and compromise. That is forbidden is that which is placed upon them.
Excuse me, you're on the same materials?
It's this one right here. I apologize. I just realized now that I did not put in page numbers. Really sorry.
Second to last page, what you have.
Oh, okay.
It says on the top, Rabbi Shaya Ditrani. Ditrani says, where they were disagreeing about between Rabbi Eliezer and Rabbi Yoshua about pshara? That's when the judge in court is ruling compromise. And they don't have any say in the process. He says, I'm going to settle this how I think best, and you're going to have to accept it. But what did Aaron used to do that's still a mitzvah, that's a positive thing? That was when it was non-coercive. When the two parties were simply really negotiating, and the judge is now acting as a facilitator, but in court, and bringing the two parties to agreement. So Aaron, in his mind, was a judge. He's in court. But the difference between that, which is consensus, everyone agrees that what Aaron was doing was great, even Rabbi Eliezer. What's problematic is when a judge stop acting like a judge and he forces the party to agree upon a settlement. Okay? So we'll go through some of the different models and we'll compare it into how this connects to ADR today. If you flip to the page beforehand, Rashi, the classic commentary on the Talmud, right, 11th century France, he explains, he says, as soon as Aaron would hear a dispute, before they would come, and here I should add, come before him to court for a ruling, he would run after them and make peace between them.
No problem with ex parte here.
So what is the distinction here between what Aaron is doing, which everyone agrees is okay, versus what's considered problematic from Rabbi Eliezer?
He was not doing it as a judge. He was doing it before there's any kind of litigation process.
Well before, meaning it's not like they're sitting in court and then he says, would you like me to rule according to compromise or rule according to strict law? He's actually, as the judge of that case, he heard that they're in conflict. He's going to seek them out and then try and bring them to some kind of compromise. That, according to Rashi, that's okay. As soon as you're doing it in the context of with your hat on as part of court, that's already highly problematic. Yeah?
This is a little tongue-in-cheek, but I'm not sure. If I'm reading the Hebrew correctly, he's talking about bringing peace between women, not men.
No, yeah.
Or is that different grammar?
Yeah, no, the rabbis did not make that distinction as we do today with the nun and the men, meaning if they're talking about men, yes, but it's good close reading. Yeah?
So I'm going on English, and I'm wondering if dispute does not necessarily mean case.
Mm-hmm.
So if you've heard about a dispute, maybe it's before it hit the court system, not in the Hebrew, to translate the case or just dispute.
It says the word machloket, just says the word disagreement. But that's interesting. Like, have they filed? Is there something that's already in the court? Or is it just simply like he heard the two of them yelling at each other? He doesn't even want it to get to a process of litigation.
Right, maybe it's preemptive.
Interesting. So it's for him, it's a question of, look, if you're out of the courtroom and you're still the judge of that case, or you're still a judge, that's okay. Okay, so that's how Rashi distinguishes it. And then a third approach is the Tosafot, which were commentaries that came after, rabbis that came after Rashi in France and in Germany. And here they say, on source number 2, that since Aaron was not a judge, right, and the case did not come before him like it did with Moshe, for him it was, of course, permitted. Right, so where is it that it's forbidden, according to Rabbi Eliezer, and where is it permitted?
So a judge can't, but if you're not a judge, then you can. Even if it's before the litigation, it sounds like a judge really couldn't do it.
Exactly, meaning like, I don't care where you are. If you're the judge, you can't start playing this other hat. Aaron was able to get away with trying to bring people towards this other process called Ridifat Shalom, or pursuing peace, because it wasn't only, probably consensual, right? And it wasn't only outside of the court, but he has nothing to do with that system because he doesn't represent the courts. He is a what? He's a civilian. He's a mediator. He plays a different. Correct. He plays a community mediator. He is a well-respected individual, and and I'll just point out very quickly, is that historically, and this was part of what my doctorate and my research was on, is that there were people throughout Jewish history who were known as Rotfei Shalom, pursuers of peace, or peace brokers, that existed both in Ashkenaz and in Sfarad, that they would enter into a conflict when they heard of two people in a dispute. They acted in a team, meaning it was never necessarily one mediator working by themselves, but they were not the judge, they were not the rabbi, and they acted exactly as students of Aaron. But they were, again, not the judge, out of court, totally non-coercive. If it was coercive, as we'll see in a few minutes, the whole process was canceled. So going back to what we have, these are some of the different models that we have within Jewish ADR. So I want to turn it over to Dan for a moment and ask, how does this kind of match up to what are some of the models of ADR that we have today as well?
First of all, thank you for your overview. These are my initial reactions. If you're to look generally at the material that covers the history of alternative dispute resolution in the United States of America, which is the vanguard of this type of dispute resolution in the world, you typically will see that it focuses on 1978, it was a conference set up by Chief Justice Warren Burger, who at the time, and he gathered leading lawyers, professors, politicians, because they were concerned that justice delayed is justice denied. It was taking 5 years to get to court. We need to do something. So they came out with this creature called mediation. Arbitration had already existed, but now in combination, mediation and arbitration. What is so rich and beautiful about learning this, and me spending time with Rabbi Roth in going through this, is to see what a rich heritage we have. Not tens of years ago, not decades ago, not hundreds of years ago, but even 1,000+ years ago. I mean, this is steeped in our oral Torah, in our Talmud. Everything that we have going on today in our system was dealt with, and on a very sophisticated level. So right now, what we're touching on is, what is mediation? What is arbitration? We all know the distinction. Mediation is where that neutral cannot impose a solution. The parties must come to it themselves. The mediator uses all persuasive power. Arbitrator imposes a solution. And then there's a mix between the two. We have med-arb. We have arb-med. Arb-med is where a judge, where the arbitrator starts, but the parties say, no, we're prepared now to talk settlement, and we will stipulate, we'll agree to let you, judge, work out our compromise. All this has been discussed just in this short passage. Now, the only one other thing I want to say is, there are added dimensions that discuss things that we don't have. There is a Hebrew word, I like it, for mediator, and as a mediator, I love it. It's a modern Hebrew word. It's called megasher, from the shoresh, the root word gesher, which is bridge, right? We bridge it. Now, I like that, except Rabbi Roth says to me, you know what? We have language that goes back many, many hundreds of years. Why don't we use that? Matavech, and what that highlights. What we just heard, I'm going to give one example of something that we don't even have in our language. And that is on the first thing that we were studying, arbitrating a compromise. Now that means the arbitrator is specifically in his head deciding, I am arbitrating a compromise. Maybe there's justice here, there's compromise here. Now, attorneys and parties, many times in critiquing arbitration, will say, I don't want to go to arbitration, or that particular arbitrator, he'll split the baby. Meaning, he will split the baby and not effectuate justice. Here, and generally speaking, arbitrators, you will not find an arbitrator saying, that's what I do. I split the baby. No, arbitrators will split the baby, but will call it justice. Here, there's a language for it. There's a language where a rabbi is saying, not only does it exist, it's a positive thing. It's a beautiful thing for an arbitrator to say, I am here to effectuate compromise. And why is that a good thing? Why is it a bad thing? And so to conclude, what Rabbi Roth said in conclusion was that nobody disputes in those texts that we saw what Aaron did, the mediator. How long ago did Aaron live? He was the first mediator. And everybody praises him. Everybody accepts what a beautiful, integral part of dispute resolution that is to get parties to a resolution on themselves. So I love the depth that this offers.
Yeah, I mean, it's a particular point of frustration that, for example, in Israeli law, there is a concept of pshara, which is when the judge rules compromise. That exists as part of ADR. But when they talk about mediation, they use the Hebrew word megasher as a bridge. But I feel like, wait, they really should be using this language of mitavech, a peace broker, or rodef shalom, a pursuer of peace. And again, as I mentioned, these are just examples that I found. They're always mentioned in the plural. Never found a rodef shalom. It's always rodfei shalom. They're always acting as a group, facilitating, because they cared about what was going on in the community. Now, they worked closely with the courts. As a matter of fact, in many communities, they brought the agreement to the local judges, and they got the stamp. So the people actually signing on it was the local Beit Din, was the local court system. So you don't always know who the mediator was. The only cases that we know of mediation are the ones that failed, because otherwise we would have never heard about them, and they wouldn't have been preserved.
Did you ever work with the secular courts as well?
There weren't secular courts in these communities. We're talking 11th century Spain and 16th century Italy and 18th century Morocco. Like, these were, working within the Jewish community. So those were you do have some instances where they've stepped into conflicts, let's say, within the Muslim community. And then I found some cases where the Muslim mediators had to step into a Jewish conflict, because they knew each other and they were respected. So it wasn't like an internal conversation entirely, but it's a very interesting system of how it worked. All of this is lost in the 1950s, meaning with the changing of how Jewish communities were structured, certain traditions simply got lost. And we'll talk about what we can do to bring that back in a few moments. So I want to now transition to the second question. Okay, those are some of the different models that are out there, and I think that can help kind of give clarity to what are Rebbe Eliezer and Rebbe Yeshua arguing over. They're not arguing over any type of ADR. They're arguing over something having to do with a judge, probably forcing the compromise, maybe not. It depends on which commentary we're looking at. But if we think about what is behind the debate, what's the value or the ethical question that stems behind these two different opinions, I'll preface by just simply saying that anytime we have a debate in rabbinic literature, it's a great training for conflict resolution thinking. As a matter of fact, I often think how I got involved in this had to do with my first week in yeshiva. I was 18, and we had studied our first piece of Talmud, and the rabbi asked us, we had a debate between two rabbis, Abaye and Rava, and he said, who do you think is right, Abaye or Rava? So being 18-year-olds, we were incredibly intimidated, and no one wanted to raise their hands. So he said, you are all spineless chickens. Vote! Who do you think is right, Abaye or Rava? He's like, low voter turnout. So we said, Abaye is right. And then he had this very deep, dry sense of humor. And did you think Rava was a bozo? And we're like, he just called Rava a bozo. And we had to keep on going back and forth until we understood how Abaye and Rava said opposite positions, but both were right. And that was sort of the cornerstone of conflict resolution training that you can get by studying some of these texts. So here we have a debate between Rebbe Eliezer and Rebbe Yeshua. So who do you think is right? No, you have to prove what. But what is the logic? Let's start with Rebbe Yeshua. Okay? Why would he say it's a mitzvah? What is so positive about not having a judge always enforce the strict, ruling when he has two parties engaged in conflict? What are some of the positive things that motivating his thinking. Yeah.
Well, it's a sense of empowerment if you can control your own destiny, participate in the decision-making process. You buy in, as the psychologists would say, and you feel better about it.
Great. So it could be. So there might be. So that the parties that are engaged in this dispute might feel more committed to the outcome as a result. What else? Yeah.
The results should be shalom.
The results are going to be shalom.
Peace.
Right. Meaning the relationship between them will be less adversarial, especially if they're living in community together, which is part of our assumption.
You don't end up with a winner and a loser.
Right. Other thoughts for Rabbi Yoshua's side? Yeah.
Sounds like also there's more of a concept of like equity or doing sort of what's fair, even if it's not exactly what the law requires. When he moves down to talking about tzedakah and mishpat, and that there's an element of not just reading who's exactly right, literally.
Right. So maybe it actually, from Rabbi Yoshua's perspective, coming to some kind of compromise, whatever that exact ADR process is actually more just because it's reflecting a deeper reality than the law is able to touch upon. So those last two parts are actually mentioned by one of the great Talmud scholars of the 20th century, Rabbi Soloveitchik, who I brought a piece. We're not going to read it inside, but you should just know you have it in your source packet, where he has a beautiful description of the importance of compromise and of Rabbi Yoshua's opinion and why that's such an integral Jewish value. And he says, first of all, he builds off the two verses that Rabbi Yoshua uses to strengthen his position. He says, first of all, it's socially more desirable, right? Because it's better for the relationship. There's the value of shalom, even if it comes on account of the strict justice. But the second one, he says, is, you know something? It actually is morally more desirable because both sides in a civil dispute had contributed somewhat to this conflict, chances are, and they're both a little bit right or wrong, and the law wouldn't have necessarily been able to reflect that as well as the judge ruling according to compromise. That is, there's a higher level of justice that might be obtained. So what do we think about Rabbi Eliezer? He didn't think of this? Why would Rabbi Eliezer disagree with that? He doesn't want people to get along?
I think that's getting to the question, why is that Aaron line there?
Pardon?
I think that we're getting to the question, why is the Aaron line there?
So the Aaron line is in there because because he's saying we all agree with Aaron, right? That mediation process is positive. Because that's not by a judge, it's out of the court systems, and it's consensual. The question is the gray areas, anywhere between Aaron and a court, that's where the areas are being disputed. So Rabbi Eliezer wouldn't have a problem with Aaron, but he would have a problem with, let's say, a judge all of a sudden taking off his judge hat and strict law and all of a sudden facilitating agreement in court. Rather, Rabbi Eliezer says, are you kidding me? You can't do that. Why?
Well, I mean, maybe it causes to a lack of faith in the judicial system because people know that a judge is going to do whatever the judge wants in their minds, so they're going to lose faith in the whole system.
Excellent. Other?
I think that there's like an ends means analysis here where if the end is peace, then that may be worth it, but if the means are judgment, then that might not be worth it. And there, I feel like that's where the disconnect is. It's that process.
Okay, great. Other thoughts? Yeah.
I mean, maybe this is a side point, but it's related to this. For me, in having read this, I don't necessarily see a conflict between the two positions. To me, it's not necessarily about the judge versus compromise facilitator. Rabbi Eliezer's position, to me, seems to be about the law is the law is the law. The law needs to cut through the mountain. And to the extent that the law isn't clear, that's where you get into this conversation about compromise, and that's why we have this secondary piece about Aaron. So for him, if you will, it goes back to this issue of divine truth being his dominant value, and whereas with Rabbi Yoshua, it's more about the human drive and set of relationships like Rabbi Soloveitchik is focusing on.
Right, so it's interesting in terms of Rabbi Eliezer's concern of the divine, aspect, which you wouldn't necessarily get in courts in contemporary. law. Yeah, we'll just take one more comment, and then I want to.
Yeah, your comment is apt about we really don't know, what this process is necessarily that they're talking about. But when I'm wearing my other hat as a transactional lawyer, I actually stopped putting arbitration clauses in agreements and recommending clients don't agree to arbitration anymore, in part because of the split the baby problem. And I just wonder whether, whether he meant it or not, you can construe it to mean, if a judge is going to judge a case, judge the case. And if somebody's right, call them right. And the other person loses. That's just the way it is. But if somebody's right and you go in and say, yeah, but take a little less, really. It'll make the other guy feel better, whatever. The split the baby problem with arbitrators, that's not right.
Right. So we don't have anyone really defending exactly why Rabbi Eliezer is saying what he might be saying. But if we think about some of the pushback against ADR, why someone might not want to go to that. I listed just two of the possibilities in terms of, is it second-class justice sometimes, like what you're referring to, and another one, are there cases that really need to be part of creating legal precedent, that if every single case goes to mediation or goes to ADR, goes to arbitration, no one ever hears about it, how will that affect the legal system? Do you want to comment about? Oh, I'm sorry.
No, there is an element of, there is some, ultimate truth and justice and the law, but there's also an element of nothing is ever that cut and dry, and there's an element of rolling the dice when you go to court. So, both parties are willing, and that's another issue. Is like both parties, as much as we want people to mediate cases, we have a huge issue at Tzedek with our cases that both parties don't want, they're not voluntarily engaging in the process, so they're forced into court, and sometimes overburdening the court. But to the extent that people want to resolve their problems, and there may be, an element of liability on both sides, mediation is probably a very, very good thing.
Consistent with what we've been talking about, the many mediations that I see are comprised of individuals coming in that are forced to come in. One of a few ways, either by contract clause, which calls for mediation first, or a law that provides for mediation, or a judge. And practically no case, certainly in California, is going to be tried before that judge sees that the mediation opportunity was exhausted. So I am often hearing cynicism in the morning when people come in for mediation. We're forced to be here. We're not coming here voluntarily. But the far majority of those settle and reconcile and reach an agreement within one day. So it's almost like a car salesman. Just let me get them in the door. But that's what I so appreciate about our heritage in Judaism. It is everybody with all these disagreements and finer point distinctions. Everybody agrees, mediate first. That's let the parties take control over the dispute. The same way a party would not go to surgery first without trying medication, diet, exercise. Take control over their body first. So let them take control over their problem, their dispute first. If that doesn't work, then turn your body over to a surgeon. Then turn your problem over to an arbitrator, a judge. But it's only exhausting that, and I love the term rodfei shalom, because that means a pursuer of peace. Rodef literally means running after, right? Running after. People use the term neutral. Yeah, I don't relate to that as a mediator. I am an advocate. My client is settlement and resolution, but I am doing everything possible. And I have the attorneys and parties know that's what I'm there to do, to advocate, to resolution, and I have them embrace the idea early in the morning that's saying, yes, we will feel so much better. You're right. 2 years hence, looking back on today, if we will know we've strained, we did everything we could to try to resolve it, but we couldn't. So that's why we litigated for the next 2 years. That's why we turned our problem over to a judge and either, and got an unfavorable judgment. but to make that effort. So I love the concept of rodef shalom.
Yeah, and I'll just add that the way Jewish law evolved is that we hold according to Rabbi Yoshua. So, and again, so you have on the far end the rodfei shalom that had always existed, that are seeing themselves modeled after Aaron, not a judge, out of court, non-coercive, and then all those different other options that have been there outside of just the strict law. And I'll just add, you're talking about the health analogy that in Hasidic literature, they liken the rodef shalom to a master doctor. And that if you think you can use the same medicine for every single case, you're going to kill a lot of your patients. So you have to know which model to use for any particular situation. And that's what it really meant to be a student of Aaron, to really know how to balance that and not to operate every single time, but also not to just, not operate.
A doctor of negotiation.
A doctor of negotiation, exactly. Doctorate. Okay, so that is in terms of some of the models, and I think that a lot of the literature speaks, and there's I brought it a little bit in the source packet. There are cases that America, for example, would look very different if those cases went to arbitration or mediation. That there is a need. Even the greatest advocates of, yes, let's be students of Aaron, still recognize the need for a Moses within the society. I think part of the challenge in my mind is, have we sometimes become too much students of Moses, as a judge or as a litigator perhaps, and not having enough of that option of Aaron. And the Jewish model always had that balance between those two different models. So I want to transition as our final stop briefly to, a couple of cases where, and this is on the last page of or second last page of your source packet, I meant of where the rodfei shalom didn't succeed. And as I mentioned, we don't have too many stories of their success because those wouldn't have been kept in the law books. And I think this is important because especially as lawyers to, counsel your clients to go through a process of mediation, what role can a lawyer be playing in helping to advise them? So one of the first case has to do with a conflict with the mother-in-law. Okay, it goes back 1,000 years. That the daughter-in-law, they got married, she simply would refuse to move into the house with the mother-in-law. And the rodfei shalom come in and they sign an agreement that they're going to rent an apartment. But then it goes to the higher court, and the court says, with all due respect, I appreciate your efforts, but you just went directly against what the law is. The law is very clear that you're supposed to, at that time, live 1 year with the mother-in-law. And if it doesn't work out and she's really yelling at you, then you can start talking about renting an apartment. So, what happens when a client shows up into mediation, doesn't necessarily know their legal rights, and they find themselves in a process that the agreement is not taking into consideration what those rights are. Maybe I'll share quickly the few. So that was one example. Another example is where the mediators were successful in getting the two parties to agreement. There's only one problem. They left the language ambiguous enough that they signed quickly, but they also just as quickly re-engaged in conflict because everyone had a totally different interpretation as to what agreement they just signed on. So, how can the lawyer ensure that when they're signing the agreement, it's really quite tight? And in that case, this was in Prague. In the 15th century, they actually had to invite the mediators to testify as to what they understood, which was highly problematic, as to what they understood was going on. And a third example,
which I might just add, would be under the state of the law in California, would be impossible because the law of confidentiality is so respected, so sacrosanct, that it is impossible to pierce it, even when there are allegations by the client of legal malpractice against the lawyer, claiming that the lawyer coerced the client into settling. That will not see the light of day as in the state of the law of California. There are attempts being made to carve out an exception and change the law, but that has not happened yet.
Right, and you mentioned the issue of coercion, which is a third case that I brought, which took place in Italy. And there, after they signed an agreement, one of the parties said, you know, I was totally coerced into this, and there was a power imbalance between me and the other side, and the mediators didn't help with that asymmetry between the two sides. And then they had to call again in the mediator and say, was that true? And not surprisingly, he said, no, we did a great process. There was no problem. But that was a question, you know, what happens when there is a power imbalance and when one side is going to say, I was forced into this. So I'm curious if you have any reflections on any of those or other cases about, you know, when things can kind of go wrong in the mediation process as well.
No, I think you covered it, but yeah, I think, you know, it's like because confidentiality is just so deeply rooted in the mediation system. It's the Supreme Court of California has ruled that everything is confidential that is communicated pursuant to a mediation, which includes even conversations a client has with his lawyer days, weeks before the mediation, in preparation for the mediation. There could be an allegation of total misrepresentation, but confidentiality prevents any disclosure. And it makes sense on, you know, from one clear understanding of why confidentiality is so important. It's to encourage parties to say whatever's on their mind, not to believe, so that they know that nothing can come back and bite them in a court if it doesn't settle at that time. So that free and clear communication is encouraged. So that's the system today.
Great. Okay, so just to conclude, I wanted to step out for a moment of what we've been talking about specifically. And just to share with you a little about what we're doing with our Center for Judaism and Conflict Resolution. As I mentioned, my academic work was on these Rotfei Shalom that had existed throughout Jewish history and kind of have disappeared from the tradition of our culture. And I feel that to a large extent, Jewish communities have become a little bit too much students of Moses, which is important, but I think we need to have a little bit of that balance. So, you know, where is this concept of Rotfei Shalom today? And how do we find that balance? And a large part of our center, which we started a couple of years ago, is to bring back that language, that model, as to being core to Jewish identity, value, and practice. And to have this idea, this notion of people seeing themselves as Rotfei Shalom, because it wasn't just, you know, the mediator. It was really anybody stepping in and saying, I care about the community. There's a sense of collectiveness and trying in a non-adversarial way to bring towards peaceful resolution. So our center works very much across religious political divides, which is really, really important to us, and trying to connect constantly, all of our programs connect Jewish texts and values with contemporary conflict resolution theory and practice, and building what we call Rodef or Rotfei Shalom programs. So we currently have a program where we're training teachers. What does it mean to be a Rodef Shalom educator? We had for federation leaders, communal leaders, what does it mean for a federation or a Jewish community to be engaged as Rotfei Shalom, whether it be their budget issues or whether it be more significant communal conflicts? We're having a program where we're training this coming year rabbinic students and rabbis, where there's lots of fascinating stories about rabbis as Rotfei Shalom or the opposite in Jewish communities. What would that mean today? We had 16 campuses that we were working with this current year in terms of what does it mean a Hillel professional as a Rodef Shalom, starting from very much the interpersonal, inter-organization issues to larger conflicts going on in campus. We have online courses. That's you. This is our first program ever for lawyers. And thanks to this, we are opening up another one in New York in a couple months, and happy to talk to you more about that. And we have we have 12 middle schools right now, 2 in LA, but throughout North America, that kids are learning what does it mean to be a Rodef Shalom, integrating in their Judaic Studies department, to training the teachers and the parent body. There's a whole program where a school can become a certified Rodef Shalom school, where the whole school community is working to bring this to their core culture of their school. And we have finally our International Jewish Day of Constructive Conflict, which is the 9th of Adar, the 9th The ninth of Adar, I brought it for you on the end, just very quickly. It's a fast day. No one ever heard of it. It's the day that Beit Hillel and Beit Shammai, the house of Hillel and house of Shammai, which were supposed to be the model of constructive conflict of how Jews could disagree but yet coexist, went to war. And according to many sources, 3,000 students died that day, and it was considered to be as tragic as the day the Golden Calf was made. So it's always been in every single Jewish book. It's there. No one ever heard about it. No one ever talked about it. So we took that day as turning it into an international Jewish day of constructive conflict. In Israel, it's called Yom Machloket L'Shem Shamayim, the day of healthy dispute. And we had about 100,000 people participate in our first year, 65 organizations around the world, across religious political divides, mediation centers. Ben-Zvi contributed a great piece on tips for mediation that can be found in your source packet. It's something that everyone can be involved in. And we have a website, nanadar.org, in English and Hebrew. And it's a great way to please share your tips and to help spread the word. And I just want to conclude, and we'll take some questions. I'm often asked how I got into this in the first place, and it comes back to also those first few weeks learning in yeshiva some 20 years ago, when a cynic came up to me after, towards the end of services on Shabbat, and said, "How do you know the Siddur has a sense of humor?" And he read to me the statement that's at the end of many tractates of the Talmud and at the end of the morning services on Shabbat that says, "Torah scholars increase peace in the world." I took that seriously and personally and was like deeply insulted. And sure enough, if you Google image that statement of the Talmud, Torah scholars increase peace in the world, like the first image that pops up are every American diplomat over the last 20 years laughing about that as their caption. It's like, really? Really? Religious leaders that are increasing peace in the world? And to a large extent, the work that we're doing is to kind of prove that the Siddur indeed does not have a sense of humor, and that Jewish learning can actually, and texts and values can actually help in making it a little bit more of a peaceful community and reconnecting those pieces of Talmidei Chachamim, of Torah scholars, increasing peace in the world. And I'll just share that in your packets, we have a little bit about our school programming and about our center in general, but also our executive learning seminar that we have a week long in Jerusalem. That's going to be this coming year in July. It's split, I think, this coming year between being in Tzfat and being in Jerusalem with a lot of serious learning, excellent teachers. You're all welcome. And I want to thank you all very much. And I want to thank, in particular, Ben-Zvi for joining and helping think this whole thing through. And to thank again our Balach Sanya, our host, Sheb, for welcoming in. And thank you very much. So we'll take a couple of questions, but